Hey guys, and welcome back to the channel. Today I've got a video for you that's a little shorter than usual, but trust me, what it lacks in length it more than makes up for in pure, unfiltered stupidity. We've got a guy in court today who is genuinely his own worst enemy, and I mean that in the most spectacular way possible. But before we get into that glorious train wreck, let me give you a preview of what's coming your way this week, because it is an absolutely stacked lineup.
If I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
I'm not sure what that is.
In regards to the right to travel under the 14th Amendment.
Okay, so that's not actually in the Constitution.
I just wanted to point out to the court that automobiles hadn't been invented when the 14th Amendment was ratified.
First up, we've got Judge Tammy, and if you caught the last video, you already know she does not play games. Well, she's back, and she's shutting down another sovereign citizen so cleanly and so efficiently that I honestly considered framing it and putting it on my wall. If you don't know what a sovereign citizen is, just imagine someone who watched a few YouTube videos, convinced themselves they've discovered a legal loophole that somehow voids all laws, and then walked into a courtroom thinking they were about to blow everyone's minds. Spoiler alert, it does not go well for them. It never does.
Mr. Gray, are you trying to get a driver's license?
Your Honor, I'm here by special appearance.
I knew that was coming. I knew that was coming. Let's just talk a little real simple, basic stuff. Are you trying to say that you can just run red lights, you can just speed, you can just do what you want to do on the roads without any repercussions at all?
Your Honor, is this a court of record? I'm sorry, is this a court of record?
As far as I checked, it was. Mr. Glenn?
Yes, it is, sir.
Then we've got Judge Perkins, who takes the time, and I genuinely respect this, to sit down and patiently explain, in plain English, exactly why the court absolutely does have jurisdiction over a sovereign citizen who, shockingly, does not want to hear it. What I love about this one is that Judge Perkins doesn't lose his cool, he doesn't raise his voice, he just systematically dismantles every single argument with the calm energy of a man who has done this 1,000 times and will happily do it 1,000 more.
So I will be countersuing Romulus, or I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well, because these are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. They completely ignored my evidence. There was sexual discrimination against me because I was a woman. It would really be a waste of the court's time.
And to close out the week, we have what I can only describe as a Karen operating at maximum capacity. This woman is so far gone that she actually threatens to sue the court, if they continue to prosecute her. Not her lawyer, not opposing counsel, the actual court itself. I don't want to give too much away, but let's just say it does not land the way she thinks it's going to. So yeah, it is a genuinely wild week ahead, and you are not going to want to sleep on any of it. But enough about that. Let's get into today's video, because this guy right here deserves our full and undivided attention.
Okay, we're on the record in McNamara versus Sylvester, case number 2018299. The record should reflect Mr. Sylvester has appeared today by Zoom video. We also have Mr. Brzezinski present on behalf of a friend of the court. This is set for a show cause hearing today regarding support. And Mr. Brzezinski, can you give me an update on this case?
Yes, Your Honor. This hearing was adjourned from February 6th for the defendant to pay $200 plus stay in communication with the friend of the court if he did not have that ability to pay. He has a support obligation of $363. This is now, I believe, the sixth show cause hearing since June 22nd of 2022. The last payment was August of 2022 at $400. So most of these hearings have not resulted in payment. Multiple times the defendant has been ordered to provide job searches to a friend of the court, which he's done, but it has not resulted in him gaining employment or making any payments. So the friend of the court would ask if he does not have employment or any income, that he provide proof of that, whether it be unpaid bills, rent, proof that he's going to the interviews, just verification of all those details to prove that he truly does not have an ability to pay.
Well, I can tell you that my phones are currently shut off with a past due balance of almost $900, if that counts for anything. And I'm behind on my mortgage. That's $606 a month. Currently don't get a electric and gas bill because something's wrong with consumers. But I can tell you that we're behind in that too. There's only one income in this house, and there is a baby due next month as well. There should be a payment made. I just filed my taxes. I received my state taxes. I know you guys do with income withholding on that. So you guys should be getting a payment for my taxes. I was supposed to get 600 and some change, and I only received $238 back. So there should be a decent payment going to you guys out of my taxes.
Mr. Brzezinski, if the court proceeds with contempt proceedings at some point, would this be a first or subsequent finding?
I believe this would be a first finding of contempt, Your Honor.
Okay. All right. So I'm going to set this for a contempt hearing in April. Mr. Sylvester, there's a couple of things that you need to do under the law. And number one is to make your payments, of course.
Okay, well, I have absolutely zero.
Can you listen to me for a second?
No, I'm listening. You guys tell me this every fucking time.
For I always tell people, and I feel like I say this more than I should have to, it is never, ever a good idea to huff keyboard duster right before you show up to court. And yet, here we are. So let's break down exactly what's happening. Because this guy isn't just making mistakes. He's actively torching every single lifeline being thrown to him in real time. Here's the thing. If he had actually been paying attention to what the friend of the court was saying on his behalf, he would have heard something genuinely helpful. Yes, he's behind on his child support payments. That part is not in dispute. But the friend of the court also made a point to highlight that there was evidence suggesting this guy had been actively trying to find employment. And that matters. The fact that he hasn't been successful yet is unfortunate, but demonstrating that you're making a genuine effort goes a long way with a judge. Courts aren't just looking at outcomes. They're looking at intent and effort too. So in other words, his own representative was in the middle of building him a pretty solid case for leniency. And then, with one single unhinged comment, this guy walks up to that carefully constructed argument and sets it on fire. And the worst part? He doesn't even stop there.
First of all, don't use that kind of language. You're in a courtroom.
Okay, what are you going to do?
What am I going to do?
I don't come up there.
I'm going to hold you in contempt. I'm going to issue a bench warrant for you to be arrested. Do you want that to happen?
No, but you guys tell me this every time. I have 92 applications out on fucking Indeed right now. I can't help that I can't get a job.
Look, I get it. Court is stressful. Being behind on child support is stressful. Feeling like you're being judged, no pun intended, is stressful. But there is a time and a place to vent that frustration, and the inside of a courtroom, while a judge is actively trying to help you, is absolutely not it. That's now the second time he's gone off, and you can visibly see the judge's patience wearing thin. He's about to get one final warning, and I genuinely hope, for his sake and for the sake of his family, that he pulls it together long enough to hear it.
Mr. Sylvester, based on your language, I've already warned you one time. If you use that language again, I will hold you in contempt.
Okay, well, as I was saying, I cannot help that I can't get a job. Okay, so I've had some places call me back, but it doesn't get me anywhere. I've had 2 interviews out of all of my applications. We've got one vehicle, one income. My insurance is actually almost expired because I can't pay that either. I don't know how I'm supposed to make payments when I don't have an income. I don't know how you want me to prove it, but I'll prove it.
Are you done?
Okay, I see where this is going.
Are you going to listen, or are you?
Oh, I'm listening. I'm going to get my shit transferred.
And he does not pull it together. So now he's staring down a contempt charge, which, by the way, was entirely 100% self-inflicted. The judge gave him multiple warnings, multiple opportunities to compose himself, dial it back, and let the process work in his favor. And instead he decided to go full smooth brain because, apparently, he thought Zoom court meant consequence-free court. It does not. But here's what's genuinely frustrating about this whole situation. And this is the part that gets me. He was getting fired up over something that didn't even require this level of reaction. Yes, he's behind on child support. The court cannot and will not ignore that fact. But what was happening today wasn't a sentencing. It was a contempt hearing, and there's a massive difference. A contempt hearing is simply the court saying, hey, we need to look at this situation. It's not a guilty verdict. It's not automatic jail time. It's an opportunity, an actual, legitimate opportunity, to present your case, show your evidence, explain your circumstances, and make a coherent argument for why you've been struggling and what you're doing about it. Everything he tried to say today, he could have said then, just, without the attitude.
All right. You just used more inappropriate language. So I'm going to, based on your conduct here at this hearing today, I'm going to find you in contempt. I'm going to order that you serve 30 days in the Otsego County Jail for contempt in the view of the court. This is a summary proceeding, and that's based on your conduct here in front of the court.
I'll speak to a lawyer.
I'm going to issue a bench warrant for your arrest. You'll serve your 30 days here once you're arrested and brought before the court. I'm also going to set this for a contempt hearing in April. If you aren't employed and you can't make payments, you need to provide proof of that to the friend.
Okay, how? You guys don't tell me any way how.
Or bring proof of that to the hearing in April.
Okay, you guys want proof, but you guys right here, this is exactly what I'm.
Okay, I'm muting Mr. Sylvester now because I need to be able to make a record and he's talking over me.
Because you guys don't give me a chance.
I'm going to, I gave Mr.
Hey, babe.
And now, because he couldn't hold it together for the length of one Zoom call, innocent people are going to feel the fallout. His family, the very people he's supposed to be supporting, are the ones who are going to suffer the consequences of his inability to keep his mouth shut for 20 minutes. There's nothing fun about that part of it. Look, I'll be honest. Watching someone confidently walk headfirst into a situation they could have easily avoided is genuinely entertaining to me on some level. But not when there are kids involved. Not when real people who had nothing to do with his courtroom meltdown are going to end up paying the price. And the fact that he's apparently planning to just ghost the judge entirely after all of this, that is not going to help him. It is not going to help his case, and it is absolutely not going to help his family.
Mr. Sylvester, I've given you more than an adequate opportunity to talk here today, and at some point you have to listen, and you're not doing that, so I'm muting you because I need to make a record. So if you don't provide that proof to the friend of the court at the hearing in April, or bring it or provide it to the court for the hearing in April, then the court will issue or proceed with contempt proceedings, and you could be subject to a contempt penalty of up to 45 additional days. So Mr. Brzezinski, if you can set that for a hearing for contempt in April, I'm going to issue a bench warrant for the court's finding of direct contempt here on the record today, which is a separate issue that you don't need to deal with, Mr. Brzezinski.
Okay, thank you, Your Honor. I will do that.
All right, guys, that's going to do it for today. Like I said, this one was a shorter video, but I wanted to give you something to kick off what is shaping up to be one of the craziest weeks this channel has had in a while. I promise you, the videos coming later this week are absolutely worth sticking around for. If you enjoyed today's video, hit that like button. It genuinely helps the channel more than you know. If you didn't enjoy it, that's what the dislike button is for, and I respect it. Either way, drop a comment down below and let me know what you think. And make sure you're subscribed with notifications turned on so you don't miss a single upload this week. I'll see you in the next one.